Okay, I think we can get started with intros. Welcome, everybody. As you know, Hubble is our ecosystem of experts, founders, and helping everybody make the journey a little bit easier, less painful, and helping folks get there quicker with advice, tips, tricks, advisory, anything under the sun. Um, if it's your first time meeting us, drop an emoji. If you've been part of a fireside chat before, also drop an emoji. Emoji if you booked a call, if you booked an expert, would love to see that in the chat. Yes. So just run of event and some housekeeping for everybody who's on the call. It'll be really cool if you guys can turn your Zoom. Just click on this right-hand button and I'll show you guys how to do this. If you click view and you hit multi-speaker, so anytime that Catherine or I go back and forth, she just pops up nice and big for everyone. Just please make sure to mute yourselves upon arrival. We will be taking FAQ during the session and at the end of the session, so feel free to pop in the questions in the chat. We'll be having a look at those. And we will get started now. Awesome. Catherine, if you want to go ahead, introduce yourself.
Yeah, hi everyone. It's such an honor and pleasure to be here with Kat. I love the Hubble team. If you guys follow me, you probably know I'm a huge fan of Kevin, Timo, Sasha, Kat, the whole team. Really, it's just an honor to be here. So I have been helping founders and businesses protect what they're building for about 27 years now. It's a big number, I know. I'm like, oh, it doesn't feel that much. So I really started out as a United States patent examiner. I was at the patent office for about 15 years. And my job there was to determine which technologies receive patents and which ones don't. So I would review inventions and issue patents to inventors, or I would have to conversely deny the inventor the patent. I did that for about 15 years. And then I retired back in 2016 because I really wanted to start my own IP consultancy firm so that I can provide customized IP strategy and protection for founders. I saw a lot on the inside that, you know, wasn't too happy with that I saw was happening on the outside. And really what that meant was that a lot of founders had IP on the table and they weren't being protected for all of their IP. I mean, there's amazing IP attorneys out there, and there's other practitioners that may not have the experience in order to protect fully, right? So I saw a lot of IP on the table, and I thought, something better can be done because these founders thought they were protected and they really weren't. And when founders think they're protected and they're not, they're making a lot of unintentional errors that are really exposing their entire startup to risk. And that risk can be anything from infringement to losing ownership rights, right? And they don't necessarily find that out until it's too late. So that's why I started my own firm about IP management. I've been doing that for a while now. And then last year, when I was judging at a lot of different pitch competitions, that's when I realized, the startup population is the most vulnerable when it comes to protecting and monetizing from their own creations. And so that's when Motley was born. So Motley was created to, specifically help founders protect what they're building.
That's awesome. I think that resonates very much within our founder community. And I always get asked this, but if you could encourage founders and to take action regarding protecting their startup in their first, let's say, 30 days, what would that look like?
Yeah. So great question. So there's different levels of protection a startup can take. But the very first critical step is to make sure that you file a provisional patent application. That provisional patent application doesn't have to cost tens of thousands of dollars, but what it does is that it establishes you as the inventor, founder of that technology, of that service that you're creating that you think is special, right? Because if we ask all founders what makes them special, why they're doing what they're doing, what are they creating, they're always going to say, well, I'm the first one to do this, or I'm doing something unique. You want to make sure that uniqueness is protected. And the easiest way to do that is to file a provisional patent application. Once you file that provisional, then you're patent pending. And now you can speak to investors, you can put it out there in the public, whether it's a LinkedIn post, website, YouTube, podcast, you're protected from an inventor and ownership standpoint. So that is the first critical step to take. In fact, I encourage founders really not to talk about what you're doing until you have that patent pending provisional on file.
And when do you think a company is like in the right kind of sweet spot to start getting that process done and to start even thinking about patent?
Yeah. So whenever founders ask me, so when should we come to you? My answer is when you wake up in the morning and you have this amazing idea, that's when you need to come to me because there's different levels of protection. So there's a way to file that initial concept. And you don't have to have a full prototype. You don't have to have the whole system planned out. There's different levels of protection that really come from the type of application that we're filing and when are we filing it. So it's really a strategy, and the strategy is also customized to every startup. Every startup's not going to have the same IP strategy. So we're going to look at roadmap, what they're building, when they're building, are they pivoting? Like what's the vision, right? And then we structure a plan for them. But really the earlier the better. And that's really because the United States is a first to file country. And first to file means whoever files the idea first is considered the owner, the inventor. And so if you're out there and you're pitching and you're not filed and you're not protected, and let's say somebody out there loves what you're doing and they're like, wow, that's an amazing idea. You know what? I'm just going to tweak it a little bit or modify it a little bit and then file. If they file before you, that's it. You have no recourse. Okay. And really, the laws changed back in 2013 because in the old era, we were first to invent country, very different laws. In the first to invent era, the actual inventor of concept had those rights, but now that's not the case anymore. It's whoever files, literally a race to the patent office to file.
That's insane. That's terrifying too at the same time, I feel like.
Yeah, yeah.
And so we actually got a question from Caroline. So any idea of the cost for provisional patent application?
Yeah, great question. So that cost is going to vary widely, right? And you want to look to see who is actually helping you with that process. You know, what is their experience? What is their background? And so I would say if you can find them as cheap as probably $200, which you probably don't want to do that, to it could be tens of thousands of dollars, right? So what I would say is you want to make sure that you interview, you meet a lot of different practitioners, and you really get a feel for their experience. Because when it comes to the filing of a provisional, experience is going to be everything, because not all provisional patent applications are also created equally. And what I mean when I say that is that there are a lot of these companies out there that will say, oh yeah, patent pending overnight, $400. But what is that filing? What is in that application? Because your patent pending status is only as valuable as what you're patent pending for, right? So if the application is like 2 sentences long, which I've seen, or 2 paragraphs long, which I've seen, as opposed to a 13-page comprehensive provisional filing, the protection you're going to get is very, very different. And because that provisional filing is the critical foundation of your entire future patent portfolio, you don't want to get that provisional wrong. So I would say you want to, most practitioners have free consultations. You want to meet them and really you want to be asking the questions, but also I would let them do talking too, right? So sometimes we tend to ask a lot of questions, but if you let them talk, you'll see a lot, right? And also the vibe and do they really care, right? About what you're building, about your journey, because unfortunately in our industry, in the IP industry, it tends to be very transactional. And in my experience, that just doesn't work. You can't be transactional when you're trying to protect someone's journey, their dream, their baby. Essentially, it's your child, right? Your startup's your child. So you want to make sure that whoever you're working with really cares and is asking those questions, and you can feel it, right? You can feel that care. That care should come through the Zoom meeting or the in-person meeting. Yeah.
Yeah, it's like with anything, right? Like when you're hiring a lawyer or an accountant, you have to get the right vibe and make sure that
Yeah,
they're really
absolutely.
into it.
Absolutely.
And then follow-up question from Caroline. Can we file under our personal name or do we need to file under our company's name?
Great question. I get that question asked a lot. So, my recommendation would be, especially when you're at the provisional stage, you can file as under your personal name. So, as an inventor, you would file. You, at any point in time, can assign ownership to whatever company, whatever entity you want. So you remember the provisional is just the start of your journey. And that journey is going to be a lengthy journey and hopefully for the good, right? We want it to be. We want the IP portfolio of your startup to be robust and really valuable. So we want to keep on adding more applications. So I would say start off filing as an inventor.
Okay, and then Benjamin actually had a really good question. So this is kind of background for him, and just for the audience, make sure to keep these questions a little bit more on the general side. And if you want to dive a little bit deeper, we're going to pop in the link for Catherine's time to book through Hubble, as we can get a little bit more granular there. But he says, we've gotten burned with a plethora of online providers, so we started to file them ourselves. These are detailed, but we know they need to have an expanded filing. We talked to a few providers, but don't really have a level of confidence in them. So, how can we find a good, honest provider and have more ready? We have more ready to file now. So this needs to be clarified. We're in AI.
Yeah. So you really like that trust factor, that meeting with that person is so critical. And I would just say, keep on having these initial consultations until you find the person. You want to make sure too, and that's why I say let them do the talking, because you want to make sure you're going with a practitioner or a firm that actually provides customized and tailored strategy, not a cookie cutter approach. It just won't be successful for the founder if it's a cookie cutter approach, right? So, and you're going to be able to tell by the questions they're asking you and also that the time they're putting into it. I've seen practitioners like look at their and they still wear the watch, look at their watch while they're talking, right? You don't want somebody like that on your team. You want and again, I would just say you can always book a hubble call with me, but but it's really about just meeting more people and taking advantage of those free consultations with some of these firms. And even if you do have to, some firms you have to pay a small fee for a consultation, but I can tell you that it's going to be worth it.
Yeah, yeah, and definitely shameless plug. I have had firsthand experience chatting to Catherine, and she is very lovely to work with. So we'll
Oh,
plug in. We plug in her link below. You'll see that come through. And then actually, Sasha asked, how do patents differ between Europe and the US?
mm, perfect. They do. So filing internationally. So international patent laws are actually much more strict than US patent law. Okay, and I'm going to get into that. So the United States, under US patent law in the US says when a founder has publicly disclosed their startup idea, and public disclosure can be anything from pitch competition, investor chat, podcast, website, social media, LinkedIn posts. When you talk about it, when it leaves your mouth and into the air, now you only have 12 months to file that application to preserve your ownership and inventorship rights. If you don't file something within that 12-month grace period that they give, that's it. You can never apply to be an inventor or founder that owns that idea again. And international laws laws don't even have that 12-month grace period because they operate under what's called absolute novelty, which means they don't want you to say a word about it to anybody anywhere until you're patent pending. So we always say any founder that is thinking about expanding internationally, start at the United States first. Start with the US provisional patent application. That's your foundation. And now you have time to expand into the international markets. But I will say IP law internationally, when it comes to that public disclosure element, very, very strict. They don't allow it at all.
Wow, so interesting. And then we have, I don't know if I apologize if I'm butchering your name, Bascom. He asked, how do I pitch to VC firms without letting them know how my IP works? If anyone tried to copy me, provisionals protect me, right?
Yeah, so that's the thing. The recommendation is don't pitch until you're patent pending. That's the best and most secure way to do it. If you have to pitch, you have to be very careful with the words that you're using in that pitch. I'll have founders come to me and say, well, I talked to the investors, right? I pitched at demo day, but I didn't really get into it. I'm like, you need to look at what that means. Get into it. There are ways that just by describing what you're doing, like the solution you're providing to the big problem, you can give away IP. You can give away enough IP that somebody skilled can reverse engineer part of it, right? So the best way is don't say anything until you're filed and patent pending. To answer his question, we have to understand what a provisional patent application does. So a provisional patent application is an application, right? It's not a granted patent. When you have a granted patent, you actually have enforceability rights, which means I'm a patent holder. Oh, that person's copying me. I'm going to go to that person and say, sorry, I have the patent for this. You have to stop doing what you're doing unless you want to license it from me, right? So a patent actually gives you enforceability rights, but to get that patent, you have to start somewhere and you have to start with that provisional patent application that's pending, right? But the actual pending provisional has a lot of power in and of itself, right? And the biggest power of all is that it establishes you as owner and inventor. So in the eyes of the patent office, your provisional is like your provisional date, your filing date is like the birth date of your child, essentially. That's when you gave birth to this idea. They recognize you as the inventor. But with that filing, you can actually, it's a very strong deterrent, right? So if others know, that, oh, wait, this guy's patent pending on this, okay, I better, watch out here. Maybe they don't want to get in those waters, right? And also, your provisional patent application can increase the valuation of your startup because provisional patent applications have value to them. They could actually be evaluated. So I hope I answered the question
Yeah,
there.
yeah. And then I had actually some interesting questions here. How do you pitch and raise money without explaining how it works?
Yeah, that's a tough one, right? You kind of really can't.
Yeah,
So the answer to that is get protected. Once you're protected, get filed, and then you can pitch and publicly disclose as much as you want.
yeah,
So
that
the answer to that is there's really no safe way to do it. You can do it, but you're completely putting yourself at risk and exposure.
yeah, it's so much exposure, and at least the potential or the provisional will kind of safeguard it and make people
Yes.
think twice. Okay. And Clanat, sorry if I mispronounced your name, but even co-founder or team members can rob your IP. I mean, that just goes back to saying you have to
Yeah.
patent. Okay.
Absolutely, absolutely. And I've seen it, right? I've seen it's really sad. I've seen almost probably every relationship, human relationship that you could think of, shattered because of these issues. Marriages, like parent-child relationships, sibling relationships. So, same with co-founders. And that's why I would recommend filing as the inventor. You're not assigning it to the company yet. So whichever co-founder, whichever founder invented that concept, their name has to go on that patent application. And that's another thing I want to point out. We have to get inventorship right. if we just want to, I have people say, oh, I want to put my child on the application. Oh, I'm going to put my investor because they're investing a lot of money. You can't do that. One of the easiest ways for your entire patent portfolio to be taken out and invalidated is if who's listed on that patent is not an actual inventor. And competitors will try to do that, right? And when they want to invalidate a patent portfolio, they're going to look at inventorship and see, okay, were those people really the inventors? And they can take you to court and make you tell them what exactly you invented, which claims belong to you. If they can prove you weren't, that's it. They can invalidate the entire thing. So we have to be careful when it comes to that. So I would, again, with co-founder situation, if you invented it, your name has to be on it. You just can't put the co-founder's name because they're co-founding the company with you.
Yeah. And that goes really nicely into the next question. So, have you seen founders misunderstand patent pending in a way that hurt them?
Yeah, yeah, absolutely. So most of the time, and what I've seen personally, when I'm on a judging panel and I'm hearing founders pitch and they say, hi, patent pending for this. So I'll talk to them afterwards and I'll ask them questions. Okay, so when did you file? How long have you been patent pending for? What are you? And then when we delve into it, they're actually not patent pending because their provisional patent application expired and they didn't know. That's the thing too. There's so many founders are in the dark because enough education was not given to them, or maybe their past experience wasn't a good one in which they were not being notified of the process and educated, right? So what does patent pending mean? How many months do you have? What do you need to do after it's filed? Right? So, and that's why I say it's so important to find somebody, find a team that's going to want to be on that journey with you. That's just not going to be like, okay, you're filed. That's great. I collected my service fee and now you're on your own. You want to find somebody that's going to want to follow up with you and make sure you're doing what you're supposed to do. Because again, it's not a one and done deal, that one application.
Yeah, that's great. And I'll give also a few people in the chat because I've seen a few questions here. But here's an interesting situation. And Gaurav, you actually may want to book a call with Catherine so she can get a little bit deeper into your specific situation. But situation, you file a provisional with poorly written claims because you couldn't afford a patent lawyer. Can someone still steal your IP by filing a tweaked patent with properly written and enforceable claim? In other words, is a provisional patent only useful if the claims are written properly by a patent lawyer?
Lot of great parts to that question. First, I want to start off by saying there's no such thing as a provisional patent. Okay. So it's always a provisional patent application. And a lot of founders, I see they're confused, like, oh yeah, I have 5 patents. And so when I look into it, I'm like, what are they? And we find out they're just provisional patent applications that are pending. We have to make sure because when we're going out there and telling investors have a provisional patent, the ones that know are going to know you don't know what you're talking about. There's no such thing. Because again, if they hear the word patent, they're going to think you have enforceability rights. That's very different than just being pending, right? So we have to first understand there's no such thing as a provisional patent. Now, the first part of the question talked about claims in a provisional patent application. You don't need claims in a provisional patent application. So you shouldn't actually be writing claims in a provisional patent application. Claims come when it's time for the non-provisional patent application. Okay, so you want to make sure that the provisional patent application can have one very, very broad claim. Again, this is all strategy, and I don't mean to bore everybody with this, but typically we say, okay, if we're going to put a claim in a provisional, let's put one claim and make it very, very broad. But you do not want it, because you know why? They're not going to get examined. Claims do not get examined in provisional patent applications. Claims get examined in non-provisionals that are going to come in the future, right? When we talk about patent strategy, patent roadmap, your non-provisionals are going to follow later at a later time when you're ready, right? So that's the first thing. claims are the most important part of your non-provisional patent application because that's what your future patent examiner is going to decide whether they're going to give you or not. So your whole patent falls on the claims. So to answer your question, how claims are drafted is probably the most critical part of the entire process. Because yes, if claims are drafted too narrow, well, that's not good for you because then you get a narrow patent and you really don't have anything, and it's easy for people to, invent around, right? But if you have a broad claims, and that's in your favor. So okay, and I'm going to tell you this from really in a very from coming from a very caring place as being a former patent examiner, because when I was a patent examiner, I would say probably two-thirds of the inventors came from law firms or different practitioners representing them, and one-third were pro se applicants. Pro se meaning they were representing themselves. So they drafted their entire application themselves. No expert was involved in that. And I will tell you, in my 15 years there, I don't probably less than five got approved without expertise involved because it's not only about what you're like, you could have something novel and breakthrough like technology, but if you don't draft the application in accordance with US patent law, it's going to get rejected. Because a patent application, there are formal matters that are all legal, and you have to draft it correctly. And if you don't, you can literally give up an amazing idea that you could have gotten a patent for just because you didn't know the law. And of course, we're not expecting pro se applicants to know patent law, right? And that's why it's critical, really, in my opinion, from my recommendations, you have to have an expert help you with the process. Definitely. Yeah.
Yeah. Yeah. It all always comes down to the people, right? And the people, it's
Yeah,
almost like who do you want to be sitting at your table with you when you're going through these
absolutely.
processes, right? Um, okay, May, I see your question, but I actually have a tickling question. What is the messiest co-founder IP dispute you've seen?
Yeah. It's Well, the messiest is that they walk away, right? And that when a co-founder walks away, especially in whether it's when they're funding, I mean, and they'll walk away because of inventorship, right? Issues. So one co-founder thinks that they, um, deserve ownership rights, and the first founder maybe that started the whole thing's like, no, wait, this is my whole idea. And that's why you have to stake your claim as inventor and owner before any really other part of the process, before you bring your team on board, right? Because also we have to worry about the engineers too and the product developers, because
Yeah,
now they may think they are an inventor. And so the definition for inventorship is pretty strict, but there's a lot of nuance to how the law can be interpreted, right? So the messiest would be, I mean, the whole startup falls apart.
right. Yeah,
Yeah.
yeah, that's like worst case scenario.
Yep.
And then May had a question. What if the people you're pitching sign an NDA and you do not have a provisional patent, but have only a trademark?
Yeah. So great. So we're gonna talk about a couple of things here. Again, and I'm always gonna say this. We have to all remember no such thing as a provisional patent. So when we say I have a patent, that means you you may or may not have once had a provisional patent application, but the point is that you had a non-provisional application and that turned into a patent. So we always have to say, I have a provisional patent application pending. That's the correct, proper way to say it. That won't get you in trouble either, because depending on who you're talking to, you don't want them to think that you have more than you do have, right? And that you're kind of trying to be misleading, because I've had investor friends tell me, like, they don't, they'll say things like, well, that founder doesn't know what they're talking about because they're saying they have a provisional patent. And so that's going to kind of not sit well, right? Um, so NDAs, they can be breached, and they are breached day in and day out. So I would never ever recommend, oh, get the NDA first in place and then file. No. The other way around, actually, and I'm going to tell you why. It's just like something I've seen throughout my years. When you're filed and your patent pending and you have the United States government filing date, That's the strongest thing that you're going to get. Okay. So, but then after that, if you're talking to people and you're like, oh yeah, I'm patent pending. And also, can you sign this NDA? That's going to be a weed out. Because a lot of times you'll hear people, oh no, I don't, no, I'm not going to do that. And it's like, well, why? It could be a red flag. And maybe then for you, it's like maybe they're not the right people. I'm not saying in all cases, in all situations that's the case. But I would say if you want the NDA to be involved, get it involved after you file. Always file first.
Yeah, I mean, it always comes back to those steps of making
Yep.
sure that you're just dotting your I's, crossing your T's straight from the beginning.
Yep.
Okay, awesome. We're going to jump a little bit into due diligence. And I guess the first question that kind of runs to mind is, what's the most surprising thing investors have flagged in due diligence?
Yeah. So what happens is that as they move along due diligence, that's when they're gonna, you know, basically make sure that whatever you said initially, like if you said you were patent pending or you said you had 30 patents, right? Total patents, because that's a big deal. You have 30 patents, that's a big deal, right? And typically what that means is you don't have 30 separate and distinct inventive concepts, like, but that what it typically means is you filed internationally as well. And so you have the US, and now those other 29 are throughout the world, which is still very, very strong, right? So they're gonna, at that point, anything you said to them in the beginning, they're going to make sure, okay, they said this, let's check. And then they're going to want to make sure that what you're building, you can actually go to market without infringing on anybody else. So that's another part I really want to stress here when we talk about protection, because there's really two parts to it. One part is get the provisional patent application filed. Establish you as the inventor, you as the owner, become patent pending, and now go talk to people about it. That's one part. The second part, which is probably just as critical, really, and sometimes could be a little bit more critical, is are you sure the product that you're creating and you're wanting to go to market with, are you legally able to do so? And when I say that, what I mean is, does that product, whether it's a service, whether it's a device, whatever that is, whatever your startup is doing, a business method, is it infringing on anybody else's territory? And that's the part that I would probably say over 90% of startups don't think about at the right time. And then it's too late. So what happens is that they'll go to market. It's great, beautiful launch. And whether it's 3 months after launch or 3 years after launch, that's when they get their cease and desist letter. And they're like, what's this, right? And when we look at the cease and desist and we go back in history and we say, well, who did the IP due diligence here? Oh, there is none. That's why. So why is this critical to do at the right time? Because if we think about it, if we're building blindly, no matter how brilliant of a team you have, if they're building without knowing what's out there, then, what they're building can still be infringing on others. So you can have a novel technology. So getting a patent and freedom to operate are two completely different things. So a person can have an actual patent on something, but still be infringing on others, right? So we have to make sure that you're cleared. So the best way to do that is to do the freedom to operate. It's called freedom to operate analysis, FTO. Do the FTO due diligence as early as possible, because what you want is you want to take those results, share them with your engineers, your product developers, the co-founders, sit at a table, look at what the risk is and say, okay, how are we going to create, invent, develop around this risk? And then as a team, move forward with a new plan, right? That's how we don't continue blindly. That's the best way to do it, because then when it's time to go to market, you've already done that risk analysis and you can go to market with peace of mind.
Yeah, with all of that already kind of wrapped up, bow, ready to go.
Yes.
Okay, and most founders, what we've seen is that they only think about IP when something breaks, which is unfortunate. But what is the most expensive too late moment you've seen?
Yeah. So what I've seen is either the entire company like shuts down, that's it, no more, or a complete product redesign, which can be very, very costly, right? Or now you're forced into a licensing deal that's not favorable for you at all, right? So what happens is, and this is on the infringement side. So if you do get that cease and desist, typically what I've seen is one of those three situations, which is so, so costly, right? Either way you look at it. The other way is that you actually think that you're owning this as startup idea, but somebody else has filed for the same concept. And then they have a patent on it. And guess what? When you're out there selling your product, they come and they enforce their own rights. So again, you have the ownership and inventorship side of it, and then you have the freedom to operate side of it. Two different, but two critical.
Okay, and then we have some questions for the audience. And guys, feel free, start popping in your questions because this is going to be the time starting now to do real Q&A and get a little bit of Catherine's time on here. So, does running an AI patent search give you more confidence that you have a unique concept to invest in the filing for you and you don't infringe?
Yeah, no. So the patent side of it, the patent side is different than the infringement side, right? So the patent search is going to look to see is this out there? Has anybody else, received a patent on it, or is this subject matter in the public domain? It can be in a publication. It can be on Amazon, right? It can be in an issued patent, an expired patents. It's really looking to see is what you have in your mind to create, what are the chances of you getting a patent on it? Kind of as is, right? Or do you have to modify before you can move forward? Because patent search results are very valuable and critical. They're going to give you an idea. Do you have to make modifications or can you just move forward as is? I wouldn't, this is my recommendation. I would never trust an AI patent search just on its own. It needs the human to review those results and review them well too. So, AI patent search those first. You have to be very careful even what you're putting in the public domain. Please, please, be very careful when you're using ChatGPT or really any of these engines because you're putting proprietary information out there. You have to be very careful. Law firms and very established IP consulting firms, they have different engines that they use that are like at an enterprise level. But again, you want a human reviewing it. So whoever you choose or whatever site you go to, make sure the product that you're purchasing has that human supervision element to it.
Yeah, perfect. And then we have Benjamin asking, can you know if there are other people that have filed but have not issued that you would potentially infringe on?
So there are certain patent applications that are confidential that you're never going to find. So it goes back to file as early as possible, file what you have, do the due diligence. The due diligence for the patent search is different than the due diligence for the freedom to operate infringement aspect. There's two different types of due diligence. The global patent search is not going to give you answers on infringement, okay, and vice versa, because we're analyzing claims, we're looking at subject matter analysis. It's a very different type of analysis that goes into each. So, but yeah, there's like provisional patent applications are confidential. So the only people that see those provisionals will be the inventor or the founders, the person that helped you draft it, and then your future patent examiner. So it's at the US Patent Office then, confidential. Provisionals are confidential. So yeah, I mean, there could be somebody that already filed a provisional, and that's why right before you talk about it, before you put it out there, file. Because you don't know who's live streaming and watching you pitch and loving your idea and filing like the next day. You're never going to know that.
Yeah. And I guess question, because this seems to be very industry agnostic. Anybody can get patent. If you have an idea, it needs to happen straight away. So what does that look like in terms of timeline, just overall from start to finish? What can that look like generally for a company?
Mhm. So to actually get an idea approved that will turn into an actual granted patent can take years. And that's gonna, that's gonna vary depending on the technology, depending on who it gets assigned to at the patent office. The patent office has always had a very big backlog. Okay. So it could take years after you apply for to actually get assigned to a patent examiner to actually review it. And then when they review it, they're going to make one decision, but that's not a final decision. That's when kind of negotiation starts. They'll review it, they'll write you back what they think. Then it's your turn to answer their argument. So it's kind of like that's when prosecution starts. So prosecution typically will start after the filing of the non-provisional application. It could take years. So, rarely do we see someone apply for a patent and get it approved like within a year. Can it happen? Yes, but it's very, very rare.
Okay, interesting. And then we have a few more questions. So this is a two-part. For a complex software or AI system, how do you evaluate whether patenting is better than trade secret protection?
Great question. So it's not the same, right? For every founder. So the determination as to whether we should apply for a patent or keep it as a trade secret, because trade secrets are very important as part of the entire IP portfolio, right? So under intellectual property, we have four main players: patents, trademarks, copyrights, trade secrets. And typically startups may have a little bit of each, right? That determination as to, hey, what do we want to put out there in a patent and what do we want to keep secret? It is going to, there's not a cookie cutter approach to that. Definitely with software and AI, there most likely will be aspects that are kept as trade secrets. Having said that, in order to get a patent approved, you have to be able to describe what you're building in such a way that the patent office can understand it. So I say that to say, if you're too vague in a patent application, it's not going to get approved. So that's a delicate balance, and we would have to look at the company, what they're doing, what they're building, who the competition is. We would have to look at our due diligence and then kind of collectively as a team decide what's in the best interest of the startup long term too, right? Not only short term in that moment, but long term the strategy.
Yeah. And then the follow-up question there is what factors tell you that an invention is actually enforceable as a patent rather than more valuable as confidential know-how, i.e., Coca-Cola recipe?
hmm So, what parts are actually enforceable? That's going to be determined by the patent office when they actually decide if they want to issue a patent to you. When they determine, so the way we do it is as a founder, right? When you get together with whoever's going to be helping you with this process, you're going to basically say, hey, I have this idea. I'm doing this differently. Nobody else is doing it. Your practitioner is going to say, okay, cool. Let's look at what you're building. And they're going to understand your story. And then they're going to do their due diligence. After the due diligence is done, they're going to come up with a strategy. They should be able to tell you at that point, hey, what you have, as far as I can see, wow, there might be a chance here. If they say there's a pretty good chance, you just go forward, apply, and see what happens. But it's really a seeing what happens, right? Because when you put it out there at the patent office, the ultimate decision is going to lay in the hands of the patent examiner that's assigned to you. That patent examiner is going to be the one to say yes or no. But you're going to get a chance to talk to that patent examiner too. It's a negotiation again, right? But if the due diligence comes back and we're like, you know what? And this is also, I need to stress this and why it's so important to trust the person you're working with, because I'm sure everybody can find a practitioner out there that will tell them their idea is amazing and they're going to get the patent approved.
Yeah.
I don't know, right? Be very
Yeah.
careful. You want somebody who's going to be like, no, if you move forward with the way as is, it's going to get rejected most likely. Obviously, we don't know definitely, and that's going to come from the experience of that practitioner. Okay. So ask about their experience. Like, how many years have you been in this field? What were your roles in this field? Were you were you just an attorney? Did you ever work at the patent office? I can tell you this straight up, and everybody knows this about me. I mean, even about IP and MLE, we have former examiners on our team. If you can find a former examiner, somebody who's worked on the inside, somebody who actually was approving and rejecting, that's going to be a valuable person to have on your team, right? And so, and I've worked in a lot of attorney examiner teams where like I'm the exam. So startups will be like, hey, we have an IP attorney that we've been working for. We really like that person, but we know you're a former examiner. Are you cool with joining our attorney as a team? And I'm like, sure, I love that. That's what I used to do with the patent office. Like then it's like collaboration, right? So it's almost like that startup then has a mini like mock examination team within their startup, right? So I go back to saying you want the due diligence is going to tell you what your chances are of moving forward as is. And so it can come back with results, and you're like, no, 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 wait, if we move forward, it's most likely going to get rejected. So at that time, then you sit together as a team, you can have your IP strategist in that meeting, and then you can build something that's better. Better meaning it's going to most likely get you the patent. It's going to most likely protect the moat, get you on that competitive edge, right? So there's different factors involved in that.
Yeah, and I have another question from Benjamin, and I see a few of you that are going a little bit deeper into your specific situations and questions. Highly recommend booking a session with Catherine. We're going to pop her link back in. What we want to use this session for is creating like those general ideas, general questions that we can answer for you. Once we get too far in the weeds, we're going to be answering too specifically for what your guys' needs are. So just have a look, make sure to book with her. And I will go back to questions. So, Benjamin, is the patent office really up to speed on AI tech? And has the current administration gutted that branch as well?
Yeah, I think they are. I have a lot of friends. I have a lot of friends that still work there. I'm also friends with some of the directors there. I'm always going to be a big fan. Obviously, there's examiners that, just like in any field, right? You have some examiners that are more knowledgeable and others that aren't. But I'm always going to be a big fan of the USPTO and their initiatives to protect inventors. So there's a lot out there in the media, but trust me, there's still a lot of good ones out there. So I believe that they are.
Yeah. Um, Now this is more of like a selfish question, but any um podcasts, books, or resources that you can provide for anybody first time patenting, anything that you have on your side that maybe we can share with everybody post event, drop a little bit of these nuggets. We'll create a PDF from everything that you've spoken about, but anything that you want to provide as a resource for everybody on the call.
Yeah, yeah. No, I can so I'm actually working on a book with a pretty big publisher. I'll let you guys know when that's done. It's still kind of secret a little bit, but I'm excited about that. And so, but I am going to be doing so. I'm in Arizona and I'm hosting a patent pending party during AZ Tech Week. I've gotten a lot of favorable feedback and response, and so I'm actually, they're asking me to come to different cities, and so this is something that I'm really looking into to see how I can travel, and I would love Hubble to be a part of that too. And yeah, so definitely, I can give you some information that would be helpful, some sites. I'm very selective again on what resources I share with everyone because as a former examiner, I have to look at it through like a couple of different lenses. So I want to make sure that anything that I recommend to anyone, I vetted and I know that, I would share this with a family member essentially because I
Yep.
would want the same thing for everyone.
Yeah. Each situation is going to be different. Okay, perfect. So book a call with Catherine. Make sure
Mhm.
that you get some time with her. Okay, we're going to pop your Arizona event in the chat just in case. I believe that you only have 15 seats. Is that right for that event?
No, well, I know we opened it up, and I got a few more sponsors that have joined. So because of that, I know I'm excited. It's gonna be fun. It's gonna be fun. Yeah, I'm excited about
Yes.
it.
Let us know also because this is something that we've been speaking about with Catherine, doing these patent parties. I mean, the offering is insane. Can you talk a little bit about what you're doing in Arizona and like how the event will go?
Yeah. Yeah. So what I'm doing is I'm hosting this event and I'm going to have a founder panel and in which founders are going to come and just talk about their experience, like authentic and raw conversation, right? Not sugar coated, not polished. Like what has their experience been? Lows, highs, like what they wish they would have known before or who they wish they would have had, right? In their circle. Just really just share their stories and try to help other founders in the room navigate like what they're going through. So that's the founder panel section. Then we're going to have an ask the examiner like kind of Q&A in which you guys, get to ask me questions about the process and you can even ask me specific questions about, what you're going through, right? We're going to do that. And then we're going to have networking with investors as well. And during the networking session, I will be actually in a just adjacent, I will be helping three founders that have been pre-selected already to essentially protect and file their patent applications. So they're going to leave the party patent pending. That's my goal. We're going to have a filing workshop kind of going on simultaneously. So we're celebrating them, being protected at the end of the party.
So excited. I want to do this everywhere with you, Catherine.
Yes, we're gonna have so much fun. Really, it's gonna be exciting just to make the process fun too, and really bring the community together. Just and anyone on this call probably knows how amazing the Hubble team is, and what I love about everyone that I met through Hubble, like they just genuinely care. It's real. The people you see, it's real. And so we just really want to help everybody share our own stories, our own setbacks, and just really just help others the best we can. So I love you guys. I love you guys.
Um, is there going to be one in New York
Yes,
City in the
there
future?
is. There is.
Yes.
There is. Yes. And I'm really excited about that. I actually spoke with the USPTO, one of the directors there yesterday. And she is excited to be a part of that. So fingers crossed, she'll be a speaker at that event in New York. So we are. I will. Yeah, we're gonna go. The plans so far I have San Francisco, New York, Miami, and Chicago. That's kind of what it's
Yes.
looking like. Yeah.
I love that. And we'll definitely keep you in touch, Caroline. We'll get you signed up to our Luma. We're probably going to be cross promoting anything that we do with Catherine. Also, big states for us to do these patent pending
Yes.
parties.
Yes.
So
Yes.
very
Yes.
exciting. We have 3 minutes open to any other questions. Please pop them in the chat um, as we kind of wrap up.
I actually do remember too, there was a question on trademarks and
Oh,
patents, and I wanted
yes.
to kind of just touch on that. I think somebody else asked. So, trademark protection is not the same as patent protection. And that was a great question that came up because founders will come to me and we talk about what they're creating. They'll say, "Oh, I'm protected." And I say, "How?" And say, "I have a trademark." So, trademark, again, we have to think of as just your name, like Coca-Cola, like Dunkin' Donuts, the name that's associated with your brand, the name that people will identify you with, right? The name. But it has nothing to do with protecting what you're actually building, the product, the service. So there's a misconception out there that you can't get a patent on software. That's wrong. The truth is you can get a patent, but it's difficult. It's more difficult to get a patent approved for software products, but it's not impossible, right? And that's why that due diligence is so critical. Is a software product you're developing, is it patentable as is, or do we have to modify it? So you definitely, it's eligible. Business methods, workflows, architecture. There's educational methods and systems that all can be eligible for patent protection, right? So one thing I would say is don't just assume that what you have isn't patentable or that what you have, oh, somebody else has probably already done it before. Don't always assume that because you can be very pleasantly surprised, right? We do our due diligence, like, wait, I thought this would have been out there. So no, so just I would say if you have something, if you're passionate, if it's something you love and you're pouring your heart and soul into, please protect it.
Awesome. Book the session for Saturday. Can I see about expanding that to 30 minutes? Benjamin just booked with you. Yes, Benjamin. Just connect
Amazing,
connect with
amazing. And
Catherine.
I see somebody asking me to come to Hawaii. Oh, I'd love to do that. Yes,
Yes,
let's have a party in Hawaii.
this girl too. Definitely.
Yay.
Yeah,
Oh
I
my
feel like
goodness.
Hawaii is always kind of the forgotten child when
Yeah.
it comes to events, and we definitely need to get to Hawaii.
Yes,
So yes,
we will talk about that.
yes.
Absolutely. Yes.
Well, thank you so much, everyone. Let me see if I have some other questions here. Great section. What's your Motely website? Adam, we will pop that in the chat and we'll get you all connected with Catherine to book a couple call, continue the conversation. I know you guys had a little bit more granular conversations that went into your specifics, but the best way to do that is through Hubble. Um, thank you so much again, Catherine. It was
Oh,
so
thank you guys. Thank you, Hubble. I love Hubble. Hubble is just the best. Thank you so much for this opportunity. It was great answering your questions. Excellent questions. And I wish you all the best. Okay. Thank you.
thank,
Bye.
thank you,
Thank
everyone.
you. Bye-bye.